You're 19 years old. You live in Minnesota. You want a concealed carry permit because you work late nights and walk through a rough neighborhood. But the state says, no, you're too young. You have to wait until you're 21. You can vote, you can serve in the military, you can buy a rifle, but you can't get a carry permit for a handgun. That was the law in Minnesota until April 2025. And that's when the Supreme Court refused to hear the state's appeal in a case called Worth versus Jacobson. And that refusal means the lower court's decision stands. The decision that said Minnesota's age restriction is unconstitutional. Now, 18 to 20-year-olds in Minnesota can apply for carry permits. And this isn't just a Minnesota story. This decision creates a blueprint for striking down age restrictions in other states. Florida, Illinois, California, they're all watching. And gun rights groups are already filing lawsuits. Welcome to the young adult gun rights revolution. And it's just getting started. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal affects millions of young adults who've been denied their Second Amendment rights based on age, and it's creating a wave of lawsuits that could change gun laws across the country. Hit that subscribe button right now so you never miss updates on cases that are expanding gun rights for young people. Here's what just happened that you need to know about. Minnesota law said you had to be 21 to get a permit to carry a handgun. If you were 18, 19, or 20, you could own a handgun. You could keep it in your home. You could use it at a range. But you couldn't get a permit to carry it in public. The state said this was for public safety. Young people are impulsive. They're more likely to commit crimes. They shouldn't be carrying guns in public until they are mature enough. That's the argument. But in 2022, gun rights groups sued. The case is Worth versus Jacobson. The plaintiffs were young adults who wanted carry permits. They argued that the age restriction violates the Second Amendment. The case went to federal court. The district court sided with Minnesota and upheld the law. But the plaintiffs appealed to the Eighth Circuit Court of Appeals. And in 2024, the Eighth Circuit reversed. The court said Minnesota's age restriction is unconstitutional. The court applied the test from the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin. Bruin said gun regulations must be consistent with the nation's historical tradition of firearm regulation. If there's no historical analog, the law is unconstitutional. The Eighth Circuit looked at history. They asked, did governments historically restrict gun rights based on age for adults? And the answer was no. Historically, once you were an adult, you had full gun rights. There were no extra restrictions for young adults. Some colonies had minimum ages for militia service, usually 16 or 18, but once you hit that age, you were treated the same as older adults. There was no category of second-class adults aged 18 to 20 who had fewer gun rights. The court said Minnesota's law has no historical precedent. It's a modern invention based on contemporary policy preferences, not historical tradition. Therefore, it fails the Bruin test. It's unconstitutional. Minnesota asked the Supreme Court to review the case. The state filed a petition for certiorari, but in April 2020, the Supreme Court denied the petition. That means the court refused to hear the case. The Eighth Circuit's decision stands. It's final. 18 to 20-year-olds in Minnesota can now apply for carry permits. And here's why this matters beyond Minnesota. The Eighth Circuit covers 7 states: Minnesota, Iowa, Missouri, Arkansas, Nebraska, South Dakota, and North Dakota. The Worth decision is binding in all 7 states. If any of those states tried to restrict carry permits to people 21 and older, that law would be struck down immediately. But it's even bigger than that. The Worth decision is persuasive authority in other circuits. If an 18-year-old in Florida sues over that state's age restriction, they'll cite Worth. They'll say the Eighth Circuit already decided this issue and found age restrictions unconstitutional. The Florida court doesn't have to follow that, but it's a strong argument. And after Bruin, most courts are ruling against gun control laws. So Worth creates momentum for striking down age restrictions nationwide. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down which states have age restrictions on carry permits and which ones are most vulnerable to being struck down next. Subscribe right now so you don't miss it. Now let's talk about the legal reasoning in more detail because it's important. The Eighth Circuit's opinion focused on 3 things: history, text, and tradition. First, history. The court looked at colonial-era laws, founding-era laws, and Reconstruction-era laws. They found no evidence that 18 to 20-year-olds were treated differently than older adults for gun rights. Young people could own guns. They could carry them. They served in militias. Some states had minimum ages, but they were typically 16 or 18. Once you hit that threshold, you had full rights. There was no waiting period until 21. Second, text. The Second Amendment says, the right of the people to keep and bear arms shall not be infringed. It doesn't say the right of people over 21. The court said 18 to 20-year-olds are people. They're adults under the law. They can vote, serve on juries, get married, enter contracts. If they're adults for those purposes, they're adults for Second Amendment purposes. Third, tradition. The court said there's no historical tradition of treating young adults as a separate class with fewer gun rights. That's a modern concept. Historically, adulthood meant adulthood. If you were old enough to fight in a war, you were old enough to carry a gun. Minnesota argued that the brain does not fully develop until age 25. Young people are impulsive and prone to violence. Restricting their carry rights serves public safety. The court said that's not relevant. The Bruin test doesn't care about modern policy arguments. You have to show historical tradition. Minnesota couldn't do that, so the law falls. The state also pointed to some historical laws that set age limits at 21 for certain activities, but the court said those weren't about gun rights. They were about voting or property ownership or other things. Gun rights were different. And the evidence is clear. There's no historical tradition of age-based gun restrictions for adults. Now, quick legal note, this is educational information, not legal advice. If you're 18 to 20 and you live in a state with an age restriction on carry permits, consult with an attorney before applying. Laws vary and challenges are ongoing. Get professional counsel. Let me give you a real-world example of why this matters. Imagine a 19-year-old woman named Sarah. Sarah lives in Minneapolis. She's a college student. She works as a server at a restaurant that closes at 2 a.m. She walks to her car in a poorly lit parking lot. She's been followed before. She's scared. Sarah wants to get a carry permit and a handgun for self-defense, but Minnesota says no. She has to wait 2 more years until she's 21. Sarah feels helpless. She's an adult in every other way, but the state says she's too young to protect herself. After the Worth decision, Sarah can apply for a permit. She goes through the training. She passes the background check. She gets her permit. She buys a handgun. Now she feels safe walking to her car. That's what this case is about. It's about letting young adults protect themselves. Now imagine a different scenario. Imagine a 20-year-old guy named Jake. Jake lives in Florida. Florida has the same restriction. You have to be 21 to get a carry permit. Jake hears about the Worth decision. He thinks, great, that applies to me. Wrong. Jake is in Florida. Florida is in the 11th Circuit, not the 8th Circuit. The Worth decision doesn't directly apply to him, but Jake can sue. He can cite Worth as persuasive authority. And if enough people sue in enough circuits, the issue will reach the Supreme Court. And based on the court's refusal to hear Minnesota's appeal, the court seems sympathetic to the argument. They're letting the lower court decisions stand. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now let's talk about which states are affected. States in the 8th Circuit are directly affected. Minnesota, Iowa, Missouri, Arkansas, Nebraska, South Dakota, North Dakota. All of them have to follow Worth. If any of them had age restrictions on carry permits, those restrictions are now unconstitutional. But what about states outside the 8th Circuit? California has age restrictions. So does Illinois, New York, Hawaii, and several others. Those states are not bound by Worth, but they're vulnerable. Gun rights groups are filing lawsuits. They're using Worth as a blueprint. And courts are likely to rule the same way because the historical analysis is the same. There's no tradition of age restrictions for adults. Let me give you another example. Imagine a guy named Tom. Tom is 18. He lives in Illinois. Illinois says you have to be 21 to get a concealed carry license. Tom wants to sue. His lawyer files a complaint in federal court. The complaint cites Worth. It says the 8th Circuit already found age restrictions unconstitutional. Illinois has the same law. It should be struck down for the same reasons. The district court agrees. Tom wins. Now Illinois has to issue carry licenses to 18 to 20-year-olds. That's how this spreads, case by case, circuit by circuit, until it reaches the Supreme Court. Now let's talk about what the Supreme Court's denial of certiorari means. When the Supreme Court denies cert, it's not making a ruling on the merits. It's just saying we're not going to hear this case. But the denial is significant. It means the lower court's decision stands, and it sends a signal. The court is letting age restrictions be struck down without intervening. That suggests the court agrees with the 8th Circuit. If the court thought the 8th Circuit was wrong, they'd take the case and reverse it. But they didn't. They let it stand. That's a green light for more challenges. Now let's talk about the arguments gun control advocates are making. They say young people are dangerous. The data shows 18 to 20-year-olds commit crimes at higher rates than older adults. Brain development research shows impulse control doesn't fully mature until the mid-20s. So restricting carry rights for young adults makes sense for public safety. But here's the response from gun rights advocates. First, the data on crime rates is not as clear-cut as gun control groups claim. Yes, some young people commit crimes, but most don't. You can't strip rights from an entire age group because a small percentage are criminals. That's guilt by association. Second, if we're concerned about brain development, why is 21 the cutoff? Why not 25? Why not 30? The brain keeps developing throughout your 20s. There's no scientific basis for drawing the line at 21. It's arbitrary. Third, young adults have all sorts of other rights. They can vote, they can serve on juries, they can join the military and carry machine guns in war zones, but they can't carry a handgun for self-defense in their hometown? That's absurd. And fourth, the Constitution protects rights. It doesn't say rights only apply when you're old enough or responsible enough. If 18 to 20-year-olds are adults, they have adult rights, including the right to keep and bear arms. Now let's talk about the timeline of this case, because it shows how these battles unfold. The lawsuit was filed in 2022. The district court ruled in 2023, upholding Minnesota's law. The case was appealed to the 8th Circuit in 2023. The 8th Circuit heard oral arguments in early 2024. The decision came down in late 2024, striking down the law. Minnesota filed a cert petition with the Supreme Court in late 2024. The Supreme Court denied cert in April 2025. So from filing to final resolution, it took about 3 years. That's relatively fast for a federal case, but it shows these fights take time. Now let's talk about what happens next. Gun rights groups are emboldened. They're filing cases in other circuits, challenging age restrictions. The Second Amendment Foundation, Firearms Policy Coalition, and others are all active. They're targeting California, Illinois, New York, Hawaii. Any state with an age restriction is a potential target. And based on worth, they have a strong argument. The historical analysis is devastating for gun control. There's just no tradition of age restrictions. So courts are likely to strike these laws down. Eventually, the issue will reach the Supreme Court. Maybe in 2026 or 2027, a case from another circuit will make it to the High Court, and the court will have to decide, does the Second Amendment protect 18 to 20-year-olds' right to carry? Based on the court's denial of cert in Worth, the answer seems to be yes. The court is signaling it agrees with the 8th Circuit, so the final ruling will probably uphold young adults' carry rights nationwide. But until then, it's a patchwork. Some states allow it, others don't, and lawsuits are pending everywhere. This information could literally expand your gun rights if you're 18 to 20 and living in a state with age restrictions. Subscribe now because my next video breaks down exactly how to file a lawsuit challenging your state's age restriction and what organizations will help you. Hit that subscribe button. Now let's talk about what young adults should do. If you're 18 to 20 and you live in the 8th Circuit, apply for a carry permit. The law is on your side. Go through the process. Get trained, pass the background check, get your permit. You have that right now. If you live outside the 8th Circuit and your state has an age restriction, you have options. You can wait for the lawsuits to succeed, or you can join a lawsuit. Contact gun rights organizations. They're looking for plaintiffs. If you're willing to be a named plaintiff, they'll handle the legal work. You could be the person who brings down the age restriction in your state. But be prepared. It takes years, and you'll face public scrutiny. But you'll be fighting for your rights and the rights of millions of young adults. Now let's talk about the counter-arguments. Some people say 18 to 20-year-olds shouldn't carry guns because they're not mature enough. They're more likely to do something stupid. But here's the thing. Maturity isn't a constitutional standard. The Second Amendment doesn't say you have to be mature to exercise your rights. It says the right shall not be infringed. If you're an adult, you have rights. Period. And if we're going to restrict rights based on maturity, where do we stop? Should immature 30-year-olds lose their rights? Should we have maturity tests for voting? For free speech? Of course not. That's ridiculous. Rights are rights. You have them because you're an adult, not because you've proven you're mature enough. Now let's talk about the practical implications. If age restrictions fall nationwide, millions of young adults will be able to get carry permits. Gun sales will increase, training classes will be busier, and some people will be uncomfortable. They'll say it's dangerous to have teenagers walking around with guns. But here's the reality. In states that already allow 18 to 20-year-olds to carry, there's no epidemic of violence. Young permit holders aren't shooting up the streets. They're responsible gun owners who took training and passed background checks. Most people who get carry permits, regardless of age, never use them in self-defense, but they have the option. And that's what matters, the option to defend yourself if you need to. Look, I spend hours every week reading court decisions, tracking Second Amendment cases, and breaking down what they mean for gun owners of all ages so you understand your rights. The least you can do is subscribe to make sure you never miss a ruling that expands your rights. Subscribe right now. And if you found this helpful, share it with every young adult you know who wants to exercise their Second Amendment rights. They need to know this victory just happened. Remember, this is educational information based on the 8th Circuit's decision in Worth versus Jacobson, and the Supreme Court is denial of certiorari. It is not legal advice for your specific situation. Laws vary by state. Always consult with an attorney before applying for a carry permit if you're 18 to 20. Stay informed. Know your rights, and if you're a young adult, welcome to the fight. Your generation is winning back the Second Amendment. one court case at a time.